I'm Katie Gottschalk. I'm the Executive Director of the O'Neill Institute, and we are very proud to have you here today. I'm going to turn it over to Margherita, who has been a staff member here for the past 3 years, and we are honored to celebrate the launch of her book today. So I will let you take it away.
Thank you all for coming to this, what feels like a celebratory event. I call it professional birthday party because this book has been in the making for so long, and I just can't believe it's out now. So I'm just going to give a very brief overview of the book, just trying to be within the 10 minutes, and then I'm going to pass it to Thomas, who is kindly agreed to chair our amazing panel with Sam, Alex, and Oscar. And then after, we're going to have the last 20-15 minutes for a Q&A. So the virtual audience can obviously use the function on Zoom to have questions. But for everybody in the audience, there are notepads with notepads with pens, and you can just write your questions there, and someone will come collect them. So yeah, thank you all very much for being here and for all the support and for showing up. It's really amazing. Very quick overview. So this book started right as my PhD dissertation, but even before that, I was just an undergraduate student, and I was just working on my dissertation. I was actually more interested on international trade and international investment, and I started, but I liked the connection we had, and I started reading the tobacco control cases, Philip Morris, Uruguay, and Australia, plain packaging. And I remember, right, and so that's really, it started really as a genuine puzzle, as a genuine research question I had. I was reading about this framework convention on tobacco control, and everybody was insisting that it's an evidence-based treaty. And I know that anyone here who's come from a public health audience, it seems like such an obvious concept, but you have to think I'm a lawyer, first of all. And I'm also, at that time, I didn't know anything about global health. And also evidence-based, actually, I'm Italian, right? And it doesn't even have a translation in Italian and in many other Romance languages. So it was also just a foreign concept to me. And I had studied so many other treaties in international law, like a framework convention on climate change, and so many treaties that had very strong scientific basis, but they were never called evidence-based. And so I was like, why is everybody calling this treaty? It's in the forward, the people talk about evidence-based. Why is that? And so I really started this inquiry. You know, I really decided to make it kind of, I rephrased it and things as a research question. And the methods I use, so this is a book very much, it's a legal book, right? So it contains some legal analysis, I promise, but it's very much a social legal book, very much in the tradition of my university, the European University Institute. So it's actually, so I use a lot of interviews, but documentary analysis, which is not just the travaux préparatoires, but it's also just the documents, the reports that were written at the time, what the people were written. So I think I really want to highlight, this is really a book about actors. So it's a book about the law, but it's really about what the actors make of the law, right? And so it's in that sense, I feel it's very much a book within the social legal tradition. It consists of 5 main chapters. So there's a long introduction, long conclusion, and then there are 3 substantive chapters which address the 3 main phases of, I call them battles of the tobacco control. The first one is the negotiation of the WHO Framework Convention on Tobacco Control. Then the second is the regime, so the establishment of the Conference of the Parties and all the other organs, which has been going on so since the 2005 until today. Actually, very soon they have the next Conference of the Parties. And finally, the litigation, right, which is also where I started. It went on basically between 2010 and 2018. So especially with a focus on Philip Morris, Uruguay, and Australia plain packaging. Just a couple of notes of what I say, right, about this book. That's so I really see this book, I really try to tell the story, what I call a unitary story. So a lot of people have, you know, like obviously been very much analyzed, was very high level disputes, very high level treating global health. But I really try, but a lot of people write either about the treaty or about the disputes. And I really try to write it as a unitary story, like with the disputes being caused by the treaty, but not just, right, as a consequence, of course, of tobacco control measures being implemented in the world and, you know, being more and more adopted. But I really see it as a story of the tobacco, like especially civil society and the public health community, using international law against the industry, right, and creating this treaty to, convince the state members to adopt tobacco control measures. And as they progressively excluded the industry from the forum, from the public health forum, the industry basically still decided to use international law and filed international disputes against them, right? They could have just reacted with the domestic cases, so they could have just, instead so it became very much what I call an international law battle or lawfare, using international law strategically to wage war. And evidence, which you remember was my initial interest, right? And is really the fil rouge of this story. And it's this is very much how I tell, and it's obviously one of the possible many ways to tell this story, but I tell this story as a story of how evidence has been used first to build the treaty, then to advance the treaty with the guidelines and many other activities of the conference of the parties, but then how evidence has been used also by the industry from the other side to attack the tobacco control measures that have been adopted. So there are two takeaways that I think are very important, and I think a lot of people in the audience may be interested, not just about tobacco control, but about global health law more generally. The main two takeaways that I wanted to share with this audience is, first of all, right, so the exclusion of the tobacco industry, Article 5.3 of the Framework Convention and all the guidelines and the other resolutions, decisions adopted by the Conference of the Parties. This is really a unique case in international law when a private actor has been completely excluded from a forum, right? I mean, to the extent that the Conference of the Parties are close to the public. Like you cannot even go as public as they're afraid that the industry may go as public. It's very important to highlight exception of this, but it's also very important to say many people, especially from the environmental field and from the food field where I also work now, really see it as a great victory of the public health community. And I do say, I mean, to some extent it is, and I also don't think it will be in any other way in the tobacco field. But I think it's also very important to highlight the story, and what my book shows is that just excluding them from the public health forum did not really solve the issue, right? So they attacked in the International Trade and Investment Forum. And obviously also they keep interfering very heavily at the domestic level, which goes back, and then the Conference of the Parties made a member state. And so you still have they're still very much interfered by the tobacco industry, just if you want, in even more subtle ways. So I really, if you want, I give a caution, right, against adopting this model for other issue areas. Then the second takeaway that I have is about evidence. And I think my public health community is always excited about evidence-based policies. And I do think, obviously, it's great to be the evidentiary basis for any measures. But I think also we ought to be very careful about framing it in a way that, like raising actually the evidentiary standard for ourselves. Because always doing evidence-based policies can also risk backfiring. And if you think, I mean, the way that the industry frame those disputes, it's really about, okay, we said the health warnings are good, but do you have evidence actually the bigger health warnings, the plain packaging works, right? That was really about, because if you always frame it as evidence-based, you really risk, making it more complicated for states to adopt innovative measures. And also just unnecessarily raising evidentiary standards. So, yeah, so those are my two main takeaways, and really thanks a lot. I'll just now leave the word to Thomas to share the panel. Thank you all very much.
Great. Thank you all for coming. I'm Tom Bollyky. I'm the Bloomberg Chair for Global Health at the Council on Foreign Relations. First, let me start with the obvious, which is to congratulate Margherita for just a terrific book. It's incredibly timely, both in terms of where we are on the fight on international tobacco control with new products coming online, electronic nicotine delivery devices, heated tobacco products. Where does this movement go forward, and what role does law play in it? It's one of the important themes. The role of international law in mitigating global health challenges. The role with commercial actors, addressing transnational threats versus domestic threats, role for civil society. All of these are brought out in the book and are incredibly relevant for some of the issues we're looking at today. And last is WHO as a lawmaking institution and how that came about and what lessons we can learn from that, from the challenges we have today. And we have a terrific panel to discuss all these issues, an all-star panel. I'm going to start to my immediate left with Sam Halabi, who is the director of the Center for Transformational Health Law and a professor at Georgetown University School of Health. He's also an affiliate researcher at the Center for Global Health Science and Security. Next to him is Alex Phelan, who is a associate professor at Johns Hopkins Bloomberg School of Public Health and a senior scholar at its Center for Health Security. Next to her is Oscar Cabrera, who is the director of the Health and Human Rights Initiative and the director of the Global Center for Legal Innovation on Food Environments at the O'Neill Institute here, as well as a visiting professor of law. I'm going to start with go through a series of themes. I'm going to start with Oscar to talk about tobacco, then move on to Sam to talk about the FCTC in general, and then bring in Alex to talk about the comparative perspective with some of the other international treaty negotiations that we're seeing. But let me start with Oscar. So the book very powerfully frames the FCTC as a form of lawfare, a conflict with an organized group, in this case the tobacco industry. In some ways, that may not be obvious to everybody here in the audience. The treaty itself has no formal dispute resolution provisions. A lot of the disputes that have arisen under it could have occurred without the FCTC as being part of it. A lot of, as the book rightly notes, a lot of the international aid that has gone to international tobacco control has been directed by the Empower guidelines and by international funding that occurs entirely outside of the FCTC. So what I wanted to draw from you is your own thoughts on why the FCTC should be seen as a form of lawfare in the fight we've been having in tobacco control, and what role it might have in where the tobacco control movement is going forward.
Thank you, Tom. And before I answer your question or try to answer the question or start a debate on that, I wanted to also congratulate Margherita. I was just telling her yesterday over lunch that it's a fun book to read. I mean, when you get it, read it. I mean, it's one that is very well written. The narrative is very well done. I mean, that approach to not just kind of like black letter law that we were discussing yesterday, but also the socio-legal approach. It just makes tobacco control feel more alive than a lot of the books that are out there. So congratulations on that, to the point that I was telling her that maybe we should think about reteaching a course on tobacco control here at the law school. So I think I'll start with that. But then, I mean, to your question, I mean, the FCTC was groundbreaking on many levels, right? I mean, you're going to talk, someone here is going to talk about the use of WHO as a form to negotiate treaties. But the issue you're bringing to the table is one that has always been a little bit of a shortcoming. There's no formal monitoring mechanism built into the FCTC. There's no way the states kind of report or have an obligation to report. There's not independent committee as some of the other treaties at the international level, in particular human rights treaties have. So I think that's something that has been in the discussions. I've been to a couple of COPs in which that keeps bringing kind of part of it. How can we build that mechanism? But having said that, the FCTC, and there's that dialogue between not just the FCTC and other international legal regimes, but the FCTC and domestic level work. I mean, at the end of the day, tobacco control happens at the domestic level, more than global sets up the stage, as a lot of the issues we work on health law. So in that particular context, I think there is a deficiency, something that maybe down the line could be improved, having not just the dispute mechanism, but having an obligation of states to report on implementation. What you just said about Empower, and I know this is being recorded and people are watching, but I'll be honest, I think it's a little bit of some of those political fights of having an external sort of WHO-led, Bloomberg-funded sort of way to measure compliance, where the treaty already has the provisions, and you could have built something to measure compliance using the treaty. I was also sharing yesterday that we're in a conference in Groningen, and everyone was talking about Empower as the way to measure compliance with international law. And Eileen Taylor was in the same panel as I was, and she couldn't kind of stop saying like, no, I mean, why are we using this kind of made up sort of acronym instead of really focusing on the treaty itself and the mechanisms that we can kind of strengthen on the treaty. And one thing that I wanted to react that was not part of your question, but it's part of like the book and the conclusion, is that idea of corporate capture in 5.3, right? And to what extent that is so unique of the context of tobacco? I mean, it is. To what extent is effective, right? And that I think it's the big piece. You just mentioned not being able to participate as a private citizen in a delegation, but whenever you go to a COP or the tobacco COP, you'll see that delegations are full of tobacco executives that just come as part of like state delegations, right? So there's mechanisms to try to circumvent that. But in that context, I think the main, for me, takeaway of the book, and you mentioned, Margherita, in your intro, is that dialogue between the actors, the processes, the institutions, and how all of that plays out. And this is still a work in progress, right? I mean, there's still more to do to strengthen. I mean, Tom, you mentioned new technologies of nicotine delivery systems, nicotine delivery devices, and that's a space that was a little bit of a blind spot of the FCTC. And now we need to rethink on how we go around and kind of try to just cover some of those gaps from the tobacco control perspective. And the last comment that I wanted to make now, I'll make it later, because it's on risk management and assessment. I think it's also something that comes out great in the book, but I'll stop now.
Great. How optimistic are you for the conference and parties being the platform by which we can sort through these new technologies? Is that really what you see as the future of the FCTC? Is focusing on that development, both of the technologies, but also the regulatory architecture to oversee them? Or is it moving to more transnational elements? Where do you see the FCTC going?
I mean, that's also a very interesting question. I mean, the FCTC used its momentum to have the guidelines, and we have a lot of normative instruments or like guiding instruments that came out of those processes. However, when we look at specific provisions of the treaty, the way you interpret it, some of these products might be excluded, right? If they're artificial derived, if they're tobacco products, and that kind of has created a lot of debate at the national level on how do we go about kind of reinterpreting the spirit of the treaty without being exclusively like looking at the black letter law of what the FCTC says. So I think it's a dialogue. I think there's opportunities at the FCTC. One of the shortcomings that I've always seen is that we tend to have dialogues between international legal regimes, but human rights law was always like not front and center in the FCTC, or we haven't maximized the potential of the existing human rights mechanisms at the international level to give more teeth to the FCTC. And that's something that now, kind of looking at Sam, that we started doing here with some local partners in 2009 and 10 when Sam was still with us, or he's back with us when he was with us the first time around. Just why don't we use like the monitor mechanisms of human rights bodies to try to give more teeth and I think there's opportunities there, but I'm not 100% convinced that will come from the FCTC. It needs to be more connected with other existing debates at the international level, new technologies, new products. I think we probably need to break that silo of everything being tobacco center and kind of go and look at other existing international regimes that can, or instruments that can help regulate new technology.
Great. You mentioned Sam, so let me bring him into this conversation. So two elements of the FCTC that Oscar mentioned are somewhat unique in that the treaty was inspired by international environmental treaties, but itself focuses far more on domestic regulation of tobacco than international regulation or transnational threats. There's no real or very soft provisions on trade and investment. There's soft provisions, as we mentioned, on dispute resolution, not a lot on cross-border advertising, leaves illicit trade for later as a solution. The other bit, of course, which was also mentioned by Oscar, is it excludes the affected industry from the proceedings. How important do you think those two design elements were to the successful conclusion of the Framework Convention? And what lessons do you think those elements might have for future treaty negotiations?
Those are both really good sort of points and reflections. I also want to sort of open with a kind of a hearty congratulations to Margherita on a really well-written, well-researched book that makes a a kind of a critical point about the use of evidence rhetorically in the context of international legal negotiation. To your specific questions, it is true that the FCTC relied in significant measure on these kind of international environmental legal precedents. But I think that it also was really cognizant of a couple of other previous developments. And Margherita, I think, gets to these in different parts of the book. And number one was this role of civil society. And all of us can I think, argue a little bit about when that precise origin was, right? But so Human Rights Watch originated, right, with this idea that civil society could play a kind of monitoring function in the arms control context, right? And then there was probably more importantly the International Code on the Marketing of Breast Milk substitutes, right? And that was very specific to a small number of actors, right? So Nestle was the most important. So I think it was really cognizant that not only was it taking the process and context from international environmental law, it was grafting it upon a world in which there was increasing consolidation of industry and industries that were particularly close to human health. And I think Margherita does a superb job of identifying, right? At the time that you really see momentum toward the treaty, there are 4 bad guys, right? And they are very much bad guys. And the fact that the treaty speaks to domestic measures was always a problem. And I think that's right. But what they did a really great job of, and it was phrased in terms of evidence, right? And I think this is illustrated pretty well in the book. And so what is most memorable is this section between pages 100 and 110, where she really focuses on this use of evidence that we have to at least articulate that these 4 bad guys act together and they act across borders, right? And so the provision on cross-border promotion advertising was always supposed to be a lot more of a meaningful reason for the treaty to exist than was ever really the case. But this idea of evidentiary rhetoric made it go forward. And in a way that's surprising, and I think is something we should all explore, is why did it work, right? It remains a treaty oriented toward domestic measures. And yet we still accept it as this kind of path-breaking and important moment in international lawmaking. I think to your second point, I think that it ends up laying the groundwork for more of those kinds of agreements in the future. And this is a point that I've made, and I think Oscar and I were there when the complaint landed on the desk of the Uruguayan government, and everybody was sort of mobilizing to say, what the hell do we do about this? And I think because the FCTC played the role that it did in justifying national measures, I think it's going to ultimately blur for the future this line between that which we regard as domestic and that which we regard as international. And not to take the conversation too far afield, but we see that playing out in the pandemic agreement negotiations currently, right? There's a lot of heat at that boundary between what is domestic, what is international, and where should international law really its role. Again, it's really a superb text. And I think she does a great job of analyzing this.
Great. Well, you set up a beautiful segue, of course, to Alex on this question of what the model or the approach that was used in the FCTC has to teach us about our current efforts to use international law to address global problems, most notably the pandemic report. And I wonder what lessons you draw out from the FCTC and how the interplay between that instrument and the way we've tried to approach health emergencies through maybe the IHR and now in the pandemic report.
So I'm going to join the other panelists in thanking Margherita, but I want to situate this in the broader international legal scholarship. I think that this piece has relevance for obviously those working in tobacco control, those working in global health law, and those working in parallel fields that she explores in the book, including international environmental law. But I also think more broadly for international legal scholarship. So, I put this as similarly transformative in the way we think about, in particular, evidence and the way we think about the language that we use when we're crafting treaties, and the strategic approach to treaty creation. So I want to congratulate you for really doing a brilliant job. I think you explore things like strategically created treaty conflicts like Ranganathan does in her piece incredibly well. And I think that's relevant for the question that you asked in a few different respects. So the first angle I think lesson we can take is this civil society angle. One thing that has been significantly lacking in the pandemic treaty negotiations is a transparent process that civil society can engage in substantively. There are pathways such as recognition of stakeholders and some public discussions, but I think Margherita's book demonstrates in itself the legal scholarship and broader advocacy benefit of having transparent processes in an output function, but also in the actual negotiation and successful implementation of a treaty. I think the second really interesting angle that this book explores that's relevant for not just the pandemic treaty, but how we negotiate treaties going forward, is this term evidence. And in the book, Margherita explores the rationale and the difference between using the term science-based policy and evidence-based policy in a really beautiful way. And I think when you look at the current negotiating text for the pandemic treaty right now, you see the words science and evidence-based policy in multiple instances. And there's a potential that this is going to open the door for significant conflicts to emerge. I think there needs to be very careful consideration of the language that's being used. And there are parallels in terms of the sorts of conflicts that may emerge that we see from this book. In particular, whilst we're not dealing with a single merchant of doubt industry in the same way that we are with tobacco, we are dealing with a transboundary threat. We are dealing with potential merchants of doubt around the effectiveness or the efficacy or the utility of evidence in policy measures. So we can see and imagine scenarios where, similar to the disputes discussed in this book, we could have commercial interests that take issue with some of the measures that might be implemented under the pandemic treaty. The final angle that I wanted to flag, and I think this is where the contribution is quite significant, is reflecting on international courts and tribunals in trade disputes and the way that they've focused in on risk regulation. And this might go to Oscar's point a little bit. The focus in on risk regulation and the sort of supply side regulation, whereas the FCTC and the disputes that emerged from this really were assessing the use of evidence-based policies that were demand side regulation. And I think when we think about some of the international law around upstream health emergency preparedness and prevention, so things like climate mitigation, these are areas where we might see similar disputes around demand side policy implementation. I'll pause there.
That's terrific. Let me draw you out a little bit more. Obviously, the FCTC happens at the same time. There's a thought of, there's the revision to the IHR. It informs any number of efforts to start other framework conventions for tobacco control. You can both here, but obviously on a number of other issues that people have proposed, whether it's obesity or so forth. How do you view that model or that interplay between those efforts having played out? And what do you think the example of the framework convention people draw from that today in the discussions that we're having now about the pandemic accord?
Yeah, I think what's really interesting about the way the model that the FCTC created is that people see the words framework convention, and that's what they take away from the FCTC lesson, rather than necessarily looking at the more intricate approach within the treaty text itself. And what I mean by that is I think people saw the kicking the can, when I say people, I mean countries, negotiators involved in the pandemic treaty now, see the framework model as an opportunity to push contentious issues to later dates, to have high-level obligations as the sort of starting point of a framework convention, and then potentially drill down on details through a conference of parties like mechanism and potential protocols going forward. And I think that's a wonderful model, but I don't think that's all that the FCTC actually teaches us about. I think the notion of evidence-based and the notion of the sorts of policies that you can try and set at the international level is much more detailed than what the lesson that people are taking away about framework conventions. In terms of how that sort of has interplayed, I think we look at the international health regulations and the revision of the international health regulations in 2005, then also the amendments that are underway at the moment, is there is a real risk when you delve into technicalities that you render that document, you render that instrument a technical document, and it loses its normative value. One of the things that the FCTC has is this incredible normative power. And I think in the conclusions you explore this really, really well, Margherita, you talk about Jekyll and Peel's work on thinking that not just our substantive content and our technical provisions, but we need to also think about the underpinning norms and values that we're wanting to use to inform the way we draft international law. In the IHR, we can see the consequences of not doing that in the way that its normative weight has really been undermined. And I think this is where some of the lessons from human rights law are really critical, thinking about how we incorporate those values.
Great. Well, let me bring in our other two colleagues on this point. What do you see as the legacy of the FCTC for our current challenges? Is it still a model to be potentially pursued on healthcare generally, universal healthcare? Is it a model for the food and beverage industry, where I know you work a lot, Oscar? Sam, I would love to hear from both of you on what you think is it a creature of its time? Late 1990s geopolitics, a particular moment for the tobacco industry, or is it a lesson we should continue to draw from today? Why don't you start, Oscar?
When you started mentioning that before, I kind of immediately smiled because in the back end of the FCTC negotiation, every topic we're discussing, we want now our framework convention, including ourselves here at the O'Neill Institute, right? We have our joint action on learning initiative that then turned into a framework convention on global health. I'm more cynic about like this at many levels. I have heard from many people within WHO, even higher level, it's like, this is one and never again. We're not doing this again. I mean, things can change. I think the momentum was, and the leadership within WHO, and Margherita, you bring that to the point in the book as well, right? I mean, having the director general elected in 98, and that was said, and she's the one that even coined the term industry interference. It's not in the treaty. I mean, we talk about industry interference, but the FCTC doesn't use that term. So I think maybe, I don't want to be that negative about this, but this is one type of product, like maybe 6, 7 type of products, one industry, 7 corporations with measures that are evidence-based, and it's easy to dissect. Even when you try to translate that to the food space, it's complicated. And if you transfer this, to global health more broadly, where do you start? You can come up with instruments that are very good from a discursive perspective, but they don't have any way to direct countries on what they need to do. And I think that's what that dialogue between global and domestic and kind of international regimes and national level regulation that Sam brought to the tables with makes sense. And that maybe was a deficiency, but I think it's one of the strengths, right? I mean, it's directing with very specific national level policies to what countries need to do. I don't know, we've been talking about a treaty on business and human rights that is stalled. I think maybe the momentum for this type of agreements is not there. I mean, it's different on pandemic because we went through one, maybe there's, but I'm not saying that this is a copy paste as a lot of actors have been wanting to do. I always tell a story in class and to people that international organizations wanted to take guidelines of Article 13 of the FCTC and say, now we're gonna control, find, replace alcohol. And let's have this to be our alcohol sort of framework. It doesn't work like that, right? So I think there's enough like lessons learned that could help think on how we can build international mechanisms to try to tackle problems that are very relevant from, you mentioned food, unhealthy diets across the board, but also universal health coverage in other areas. But I'm not sure if the framework is 100% kind of something we can transfer. It's more of a process that we learn and see where we go with it. But I think it's very specific and unique of tobacco, the industry, the moment we were, the evidence we had, the case law in the US that led to have that amount of like, evidence that we don't have that even in the food or alcohol space. So I think we're a little bit far from it.
Great. Let me bring in Sam on the same question, but also I'd love if you could talk a little bit about WHO as an institution, where it was in the late 90s through this process and whether or not it plays the same kind of role internationally. It could lead an effort like this.
No, it's a really good question. So I rarely disagree with Oscar, but on this particular occasion, I will. So I actually think it can't be understated the extent to which an oligopoly existed at the moment that the FCTC was formed. It became a lot more manageable to target those corporations. It became a lot more manageable to make a kind of a common dialogue about them, with the arguable exception of the Chinese tobacco monopoly, which is still, so, you know, at the time that the negotiations were occurring, you saw a little bit of kind of complexity and diversification, right? Kraft had sort of tobacco and beer and, you know, sort of a bunch of other things. Once they peeled away those tobacco industries, they became a lot easier to target with regulation. I think it is the same, right? I think the world now has 3 major brewers. I think it has maybe 4 major distillers, right? And as the evidence builds on the truly deleterious effects of alcohol consumption and how aggressively it is promoted to youth, to vulnerable communities, I think you're going to see that roadmap be appealing elsewhere. But I think that it is also an important point to say, well, even if that's true, what would be the credible body to bring a new instrument to bear on those? Could it be the World Health Organization? And again, it's sort of to point to the, you know, the excellence of the book. Margherita does a really good job of analyzing the idiosyncratic strength of Grow Harlem Frontline. And really, if you set her against, I would say, any other DG of the WHO, you know, none of them can really hold a candle, right? So she was an accomplished politician. She was an environmental minister. She was, you know, technically proficient. And I think it might have a lot more to do with who the DG is in shepherding that process, because really since she stepped away, the World Health Organization has lost a lot of credibility. It lost credibility in H1N1 for declaring a pandemic too soon, and Margaret Chan looked like she was carrying water for Big Pharma. Sort of, you know, Tedros, I think, has been great, but he is caught in the politics of a new pandemic agreement. And I think yesterday, the day before, even he said, "Oh, we might miss the deadline." Right? So you have somebody who equivocated, I think, at a point in time when Frontline wouldn't. So I think it's a fair point to raise. I think a lot of it depends on the strength and credibility of the DG. But it's certainly true that I think WHO has less of that really strong sort of faith that it did in the mid-90s.
Great. Let me bring in Alex. So I agree with what Sam just said, but one of the things that's also different from the late 90s is the global health governance space is vastly more crowded than it was. WHO had a monopoly to some extent, which starts to change around the rise of HIV as a foreign policy concern and the number of the other movements that happen afterwards. You work a lot on climate. And that will obviously be part of the discussion around the pandemic accord, but is another area where there are a lot of other institutions involved. How do you see the WHO's evolution as a lawmaking authority to address today's challenges? What lessons do you think they could draw from the FCTC experience, or is it just an example they should put aside and move into today's world?
It's a really interesting question. I think there's often been a lot of diverse opinions about why WHO has not embraced lawmaking in the same way. And I think Sam's very much on the money in terms of it being so DG personality dependent in terms of championing a cause and running with a cause. And I think in the book, Margherita also explores the idea of that this is a very technocratic institution. You know, I think if we look at the evolution of WHO in setting these technical standards and embracing its role as a technical standards organization has meant that it's often missed the opportunities for its ability to use law as a tool to set norms, to set standards and expectations of behavior of states. And WHO is very, very deferential to member states to a point in which I think it has also impacted its willingness to step forward and embrace lawmaking. How does that play in the broader global health governance space? And what lessons can we take from climate? And it's really interesting seeing WHO step into climate more as a bit of an aside. And I think that's it's interesting because it's an international organization that is one of the very few that legally has had a slap on the wrist in terms of mandate, in terms of when you might recall the nuclear weapons case back in the 90s, which defined where WHO can where an international organization can operate with regards to its constitution. And I think that's relevant because we see other international organizations interpret their mandates broadly. We see, particularly in the climate space, a proactivity. And I think this, again, is largely driven by civil society, not necessarily international organizations, but largely driven by civil society. To embrace that lawmaking and embrace lawmaking that extends mandates. So for WHO, what I think the lesson is perhaps to go back to testing the limits of that mandate, thinking about what it can do using law to protect public health and the utility of law. The final lesson, I think, from the climate space in terms of governance here is that the world doesn't stop when the treaty is concluded. In fact, some of the most important developments that occur and compliance that occurs is as you build that trust between nations through things like conference of party mechanisms. I think the big lesson for WHO is going to be preserving that conference of party mechanism. And that's going to be a really difficult line for it to draw in terms of the balance between civil society and industry that I think WHO really struggles with, even though it's slowly developing frameworks and guidelines around it. I think we've seen in the climate space, the Conference of Parties really start to be degraded by the influence of industry at the member state level and at the direct engagement level. So I think preserving those COPs, if we have a pandemic treaty and for the FCTC, is a really integral lesson.
Great. Great answers. So we've had a discussion, obviously, with our three panelists here, talking about Margherita and her brilliant book. The good news is we are now turning it to questions, and you can actually also ask questions to Margherita about her book in addition to these panelists. So I want to give you the opportunity to do that. Why don't we look around the room and I'll call people in the order that your hand goes up. While you think about your questions, why don't I give Margherita a chance to respond to some of the discussion we've had on the panel, since we've been mostly talking about her, and she is the expert who's written the book. So let me give you a chance to opine on some of the themes we've talked about, whether it's the design or the lessons for WHO today, or how you would connect it to current proposals for WHO to engage in lawmaking.
Thank you so much. Well, first of all, really, I want to extend thanks to you for chairing so brilliantly the panel. Oh, we have some questions. Sorry, we have quite a work.
Well, you start.
But for being, really amazing discussion and for all the kind words. So thank you all really so much. I think I mean, as usual, right, I took a lot of notes. I think I'm going to keep thinking a lot about this. As usual, you think like, oh, not reopen the book. I would never do that, but maybe write something else. The book, I'm very happy that is out. But I think I found very interesting, and perhaps something that I wanted to pick up. I found very interesting Sam's remark about, alcohol, where having only 3 breweries and 4 distilleries. I didn't know that the alcohol industry had become so concentrated. And I I think I definitely agree that it was right. And we always think of the concentration, right? The rise of mega corporations and things in financial terms is what they makes them invincible, right? And the tobacco industry is still really thriving. Don't invest, but I think they're still making good profits and they're still doing great. So I think it makes them invincible from the pure corporate point of view, but politically, geopolitically, right? The fact that it's concentrated in fewer countries means fewer hands are available to defend them. So I do think I didn't know this fact, and I'm definitely going to keep researching. And I think I could definitely see. And yeah, I think I also found very interesting the remarks about leadership, right? And I think I was discussing it yesterday how much when I started as an undergraduate student, things where people were talking about the importance of leadership seemed this very vague concept, and I could not really grasp it. I was like, why are people so obsessed with it? But actually, you know, having studied this story, having seen it, and I think the more you look at this thing, you more realize how much individuals at the end of the day can really change the course of events. But I'm going to stop here because I think we have got quite a few questions, and I don't want to.
Yes, we do, and I have managed to botch the procedure. So what you're meant to do is apparently write down your question on these cards, and I will read them. So the first one is a great one, and it gets at a theme in the book that I hadn't had a chance to ask a question, which is the question itself is, why has the criminalization of the tobacco industry tactics attracted so much international jurisprudence? This gets to one of the really provocative claims made in the book, which is it's by the exclusion of the tobacco industry that we have seen that have spurred some of the cases that we've seen that they might not have otherwise happened if the tobacco industry was a participant. And I wonder if that's a fascinating proposition. I wonder if it's one the panel agrees with, and whether or not you see the litigation we've seen around tobacco control as being different from what we've seen in other areas like food and beverages. Anyone want to take that on?
I mean, I'll offer a few brief, I don't. So we have, and by the way, it's probably important for those of you who are anywhere in your research career to visit the document libraries they're mentioned in the book. They're a really critical source of information. Again, at the time that those documents were being uploaded, a lot of those industries were more consolidated, right? So you actually have an enormous amount of information on how alcohol is marketed, how terrible foods are marketed. It's just a kind of cornucopia of great research. One of the things that you discover when there's definitely like a little bit of you can get into a rabbit hole on it, is that they would first make sure that they were at the table. They would use their position at the table to make whatever regulation or law it was terrible and not work. And then they would sue after anyway, right? And so you don't win by including that, right? And there are some countries with strong constitutional traditions of participation, and the guidelines on Article 5.3 would never be enforceable in the United States. I get it. But I don't think excluding them gets you more likely to a lawsuit. Like there will be. So you see it in the Inflation Reduction Act, right? So demand to be at the table, argue on sort of how the Medicare negotiation for a very circumscribed list of drugs will go, sue anyway, right? So that part I would probably contest or challenge or.
You know, I think a lot of this comes back to our questions about what values are we wanting to entrench. I think that there is no, from my perspective, there is no right to participation for an industry that creates a product that does nothing but kill. And the inclusion at the table is only disruptive for the very points that Sam mentioned. And at the end of the day, the litigation, whilst there are significant downsides and there are significant time costs, people costs, resourcing costs, and burdens particularly placed on a range of different countries, at the end of the day, the litigation also, we've seen measures upheld. I do note the nuance of, by restricting it, you do potentially limit yourself going forward. But I don't see there's any particular, I think there's a strong reason not to have industry at the table from a values proposition.
I'll just add, I'll continue disagreeing with Sam because we're living out the wine industry and the complexity of like, why is Australia a leader in tobacco, but not on alcohol? Why South Africa will never take on to be the leader that they were in the FCTC? So there's all the other like big sector that will have an influence, but we can have that debate on alcohol at smaller point. But I think here, when we frame industry interference in those like broader terms, we also lose the opportunity to really engage with private actors when they're in line with what could be public health goals. And I know that we have said in tobacco, there's never an alignment, right? But illicit trade has proved that differently, right? Tobacco companies can be allies of states that want to try to strengthen points of entry because tobacco companies also have an interest in reducing illicit trade of tobacco. So I think that there is, and I agree that we need to continue to push for the higher sort of threshold, but there are points in which that dialogue needs to happen, right? I mean, we see that in the food space. We see that in other areas in which it's really hard to dissect them and exclude them. But I'm discussing this, I mean, I'm answering this comment to this from more of a like more pragmatic approach on how we can strengthen implementation of those rules, but I don't see any risk of excluding them in a lot of, I mean, if you have a rationale for excluding, I don't see any kind of legal risk.
Great. We have two more questions. They are both directed towards Alex, but I think others can answer them as well. They are about the pandemic accord negotiations. One is that you mentioned the role of or participation being open to civil society, and the questioner wants to know whether that should apply to big pharma as well. So to build on our conversation here, big pharma for some people being the bad actor in similar to the tobacco industry and the FCTC being the bad actor in the pandemic accord. Do you think those should be open to them? The second question is more about the technical elements and the normative value in the treaty negotiations, and how should we think about that when the research, notably the science, is constantly evolving? Should we, in thinking of the pandemic accord, should we opt for more of again, a framework approach that allows the details to be settled later under broad commitments? Why don't you start us off with those two questions, but I think the others can speak to this as well.
So I think the starting point is I don't think you can have that big pharma and tobacco aren't analogous. Big pharma, whilst we can talk about the prioritization of corporate profits, we can talk about that side of things, they are producing products that save lives. That being said, IFPMA and the International Pharmaceutical Manufacturers Association is incredibly influential and incredibly vocal during these talks, and has the ear outside of these negotiations of member states and groups of member states in a pretty significant way. And I think that has been quite detrimental to progress on creative solutions for a number of equity provisions under the treaty, particularly around equitable benefits sharing or the establishment of a pathogen access and benefit sharing instrument. So I think that it is a real challenge for WHO of threading that needle of involvement of organisations that do engage in good, but can actually have quite negative influence on equity provisions. On the second point about the technical aspects of a framework approach, I think just one thing that reading jumped out to me, and we're talking about the leadership of Director General Brundtland. And in your book, you talk about how she established the evidence-based policy division. So she not only was, behind pushing an evidence-based lawmaking, but also within WHO. And it's interesting to me that we have a parallel with Director General Tedros, who has established a science division, the chief scientific officer, and now legal text that uses the phrase, science and evidence-based. So I think we've got a broad commitment to creating a research environment that a framework convention approach, I think, is much more facilitative of. I think the challenge going forward will be, is WHO the party involved in defining what is the best available scientific evidence? And how do we actually have that conclude the debates on certain issues, I think is the biggest challenge with any model that's used.
Great. Sam, Oscar, would either of you want to weigh in on those two questions? Any last remarks?
So yeah, she captured everything that I would have reflected in.
How about you? Any response to those questions?
I just wanted to say I had not reflected on the fact that now the term uses science and evidence-based. I think I could write a whole paper on why the need to add science, which could potentially, I think it could potentially help some of the because evidence or the difference, evidence is the studies, right? The papers, what we publish as papers, and science will be more general principles. So theory could help some of the downsides of the evidence-based approach, but I think it could also actually raise the evidentiary standards. So it's very interesting, very interesting. So I think it's, I think there is definitely a very interesting parallel with what Dr. Tedros is doing, and maybe I'll add it to the list of papers that I need to write. Thank you so much, Alex. It's wonderful.
Great. Well, I hope you take the richness of this discussion as evidence that it's a great book. It's well worth reading. It's well worth buying. I really enjoyed reading it, and you can see from our panelists that it provoked a lot of great discussion and thought from us. I hope you will join me in congratulating its author on its publication.
Thank you. Thank you really all for coming to the virtual audience. And I think I'll especially shout out to our comms and events team for being amazing and having put everything together, and Indira and Natalie for supporting it. So really thank you all, and obviously the panelists for joining me. It's been really an amazing conversation, and I'm extremely grateful and humbled. Thank you so much.
Thanks.